Hi, everybody. Glad to be here with everyone. We're just going to jump right in if that's okay. And so essentially what Melinda had asked me to talk about is, will your estate plan work? So a lot of people have estate plan, and maybe just by show of hands, how many people have an estate plan? Have wills, powers of attorney? Okay. Well, so for people who have them, don't have them, kind of have them, this will be a good review, and it'll also talk about what is an estate plan, what makes up an estate plan when you hear that term, if you will. So estate planning, why do we have estate planning? Estate planning helps us with a lot of different things. It helps us if we pass away and we want our stuff to go to certain people. Estate planning can help us avoid that probate process, having to go to the probate court to get our stuff where we want to go. It helps us if we're not able to make our own decisions. It allows us to be able to make sure that our decisions are going to be made by the persons that we want to be in charge, and that the decisions that we would otherwise make are going to be made for us. It also helps us, when I say plan for beneficiaries, it helps us get our stuff to the people we want, when we want, and how we want. And we'll talk about what that is. And most of all, estate planning really, in my heart of hearts, I hope, avoids chaos and family fighting. My office is downtown Grand Rapids, and I look out and I see the probate court. That's what I get to see every day. That and the helicopters that land on Spectrum. So I have two really good views. But that probate court is filled with chaos, with people who haven't planned or haven't planned properly. And now we have to get to the probate court so we can get someone, a judge specifically, to say, okay, this is what's going to happen. So with that, we're going to talk about estate planning documents. So these are the four main estate planning documents that people have. The first three are what I would call our most basic estate plan. These are the three documents we should all have. And the fourth one, the trust, we'll talk about. Not everyone needs a trust, but we'll talk about when you might need a trust. But each one of these documents, if you think about them, they are really emergency documents. They say, oh, there's an emergency. The emergency with the first two is that someone is incapacitated. With a will, the emergency is someone's dead, and a trust could be both. It's a hybrid. So all of them say, whoop, stop, there's an emergency. And then the document tells us who's in charge and what they're allowed to or what they're supposed to do. Okay? So if you think of it from that perspective, you're planning, gosh, if I have an emergency, if I become incapacitated or I'm gone, who do I want to be in charge and what do I want them to do when this emergency is happening? And that's really what estate planning documents are. So we're going to talk first about a durable power of attorney. So Michigan, just FYI, in November of 2023 passed the Uniform Power of Attorney Act. And you're like, why do I even care? Well, you probably don't need to care, but I just want you to know, because what I anticipate is the law becoming effective in July. Banks specifically were very much behind Michigan adopting this Uniform Power of Attorney Act. And this has been going on for 12 years. They've been trying to get this passed, and it finally passed. And for banks, most banks are national, right? We've got Chase Bank, PNC, Fifth Third, they're all over the country. And they wanted to say, when people bring us their durable power of attorney, if someone's coming in and they're saying, Catherine's incapacitated, here's my durable power of attorney, I need to withdraw money, or I need to do this, that, or the other thing, they want sort of a uniform document. They want a document that hits all the same high notes, because they're looking at millions of different attorneys who are drafting their own version of a durable power of attorney, or the ones you get online. And so they wanted something to say, here are the things in Michigan that you need to have for a durable power of attorney. So for those of you in the room that have a durable power of attorney, banks cannot tell you that your document is invalid. The law specifically says that it does not invalidate prior durable powers of attorney. So if they push back on you on that, you call me and I'll push back on them. So they shouldn't tell you that. But there are some things that you should know. If your document is not notarized, then it's not durable. Well, what does that mean? You can have a power of attorney or a durable power of attorney. Durable means that it is still effective if you become incapacitated. So if you've got this power of attorney document and you think it's durable and you think that it's going to be effective when you're incapacitated, but it's not notarized, you're going to have a problem. Okay, so you just want to check on that. In Michigan, your durable power of attorney can be effective the minute you sign it, or it can be effective when a trigger happens, and usually that trigger is you're incapacitated. So I generally recommend that durable powers of attorney are effective immediately. Certainly it's specific to every client, but I'm just gonna, a lot of clients bristle at that. Oh, I don't want to put so-and-so in charge now. And I'll say, well, why don't you want to? Well, I don't want them going into my bank account or looking at things online. And so my thought is, well, if that person would do that, then they probably shouldn't be named as someone that you would want to act on your behalf. But the reason I like them effective immediately was really highlighted for me, especially during COVID. Because during COVID, I would have clients who had capacity. They weren't incapacitated, but maybe they were in the hospital, or maybe they were in assisted living or a skilled nursing facility where we couldn't get in to see them. And they might not have had access to be able to pay their bills, and they needed someone to pay the bills. And we were in this quandary where we couldn't get that done. And so we couldn't get in to have them sign a new durable power of attorney, making it effective immediately. So it just caused some issues. So I will give you an example. My durable power of attorney is effective immediately, and it names my spouse. So right now my spouse could be talking to Warner, Norcross, and Judd and liquidating my 401k if he wanted, right? But at least we know that I wouldn't have to be incapacitated for him to be able to go ahead and help me out in that regard. So there's something to think about as you are either looking at your durable power of attorney. If you have one, you really should look, and I gave you those little checklists, and those are to sort of help you if you have your documents or you are going to have documents prepared, things for you to think about as you're looking at those documents. And so on the durable power of attorney, I have effective when, because sometimes you read them and you can't really tell, but you should know, when is your person allowed to act for you? Do you have to be incapacitated? And who decides that? Every document is different. Some documents say it has to be one doctor. Some say it's a doctor and a licensed psychologist. Some say 2 physicians. Some have something called a disability panel, where no doctors have to find you incapacitated, but you appoint a panel of people to make that decision. You could say, I want it to be my spouse and children. If my spouse and children say I'm incapacitated, then I'm incapacitated. So you get to make that decision, but you should know what triggers your document to be effective. I'm just going to say durable powers of attorney can be very narrow or very, very broad. An example of a very narrow power of attorney might be in a real estate transaction. So sometimes we have clients who maybe they're closing on a house up north and they don't want to drive up north to the closing, so they give their realtor a power of attorney specific to do that closing. That would be a very, very narrow power of attorney. In my world, when we're drafting powers of attorney, we're usually making them very broad. We're trying to think of what are all the things that I might need someone to do for me if I was incapacitated. Pay my bills, file my taxes. What if I'm in a nursing home and I need to sell my house? Who could sign a deed for me? What if I had a business? Who could manage that business? What if I needed someone to sell my car? Any transaction that I might need to do if I was incapacitated, that's generally what I'm trying to cover in a durable power of attorney. One of the things that I like people to understand is sometimes, so let me say it this way, sometimes clients will come to me and they'll say, my mom, she's at the hospital, they're going to discharge her to rehab, and they said I need to get a guardian and a conservator. So my first question always to them is, well, does your mom have a power of attorney? Oh yeah, she has one. Well, if she has one, she doesn't generally need a conservator, because the job of a conservator is the same as a job of someone who's named under a power of attorney. So when you have a power of attorney, it's really meant to avoid the need for a conservator. And so I'll give you a better example of what I mean by that. So if I am, well, I should say it this way, anyone who's over 18 should have a durable power of attorney, because once you are an adult, the law says no one can come in and manage your finances or do anything unless you appoint them to do that and give them the authority to do that. So today, if I had a bank account just in my name, a Chase bank account just in my name, and I didn't have a durable power of attorney, my husband could not go to Chase Bank and try and withdraw money and say, well, you know, I'm Catherine's husband and she doesn't care. She said it's fine. They would say, no, we're not going to let you take out any money because we don't have anything to tell us that you have authority to do that. So that authority could come from a durable power of attorney. It's the same, I have 4 children, young adults, and they all have bank accounts, and I'm sort of still footing the bill for a lot of them and paying their school and health care, and they have bank accounts. I couldn't go in and say, well, I need to withdraw money from their account and I'm their mother. They would say, well, lucky you, or congratulations, or poor you. So when you're an adult, you need to have someone to make a decision. The durable power of attorney is you saying, this is who I want to make decisions, and these are the decisions I want them to make. If you don't have a durable power of attorney, then we have to go to court and get a conservator. So oftentimes I'll have the other situation where someone will call me and say, you know, my mom's in assisted living, someone needs to sign the contract, someone needs to be able to pay the bill, and I went to the bank and I'm not on the account, what do I do? Well, then we find that we have to go to court and we have to get a court to appoint a conservator. And it's not ideal, and I'll tell you why it's not ideal. First of all, it's a lot of money because you have to petition the court and you have to pay court fees. The court is going to appoint a guardian ad litem, and it's sort of the investigator for the court. You have to pay for the guardian ad litem's time to do that investigation, to write a report, and to show up at court. You're going to have to go to court. If it's my mom who's incapacitated, they're going to go talk to my mom, and they're going to make a public declaration in the court that my mom is incapacitated. And sometimes that's just a very hard thing for that person to hear, someone reading a report saying that they're incapacitated. The court may or may not appoint the person that you would want. So I would choose my husband to be my agent under my power of attorney, and then maybe my oldest daughter, Chloe. Well, if we had to go for a conservator, and let's say my husband predeceased me, and so I would pick Chloe. I have 4 children. All of them would probably fight to be in charge because they all want to be in charge. And so now we've got a big fight, and the judge has to decide which one of them he should pick. And he doesn't know that I would prefer Chloe. Now I feel bad that this is recorded. I'm just kidding, other kids. I just thought about that. Chloe's the oldest, so I'm just going with that. So the court doesn't know that I would pick Chloe, and maybe she doesn't present as well in court. Oftentimes I find when we're in court and all the kids are fighting, the judge honestly says, screw all of you, I'm going to appoint a public conservator. I'm not going to appoint one of you family members because you can't get along. And so then when you get a public conservator involved, your family is cut out. They're going to have no control over your finances. Someone is going to be in charge of everything. So I can't stress enough how important it is, if you want to maintain control, then you need to have this document. All right, I'm going to move on to the next one. Maybe? Oh, there we go. And that is sort of the companion to the durable power of attorney, is the patient advocate. So those are the 2 documents that we have while we're alive. So sometimes people will say, oh, don't worry, I'm someone's durable power of attorney, or I'm someone's patient advocate, and they're calling me and they say, you know, my mom died, but I'm the power of attorney. And I'm like, well, congratulations, but that document dies with you. So the durable power of attorney and the patient advocate, only good while you're alive. Patient advocates, just so you know, are for health, welfare, well-being. So they're sometimes people call them the pull the plug document. It definitely is a document that allows for you to make decisions about who might pull the plug, but where they really come into play is who's going to make sure that mom has a place to live? Who's going to decide where she's going to live? Who's going to decide what doctor she's going to see or not see? Who's going to decide if she's going to have another round of chemo? It's more rare to see that document come into play because we've got to get someone to pull the plug. It's really the everyday stuff. So it's health, welfare, well-being, and end of life. Much like the conservator, under a durable power of attorney, if you don't have a patient advocate, then we're going to have to go to court and we're going to have to ask the court to appoint a guardian for you. And the same is true. I tell Melinda this all the time, at least once a quarter, I'm in court for, it's always a boy. I don't know why, they're just a little more risky than girls, but these 18 to 23-year-old boys do something very risky and they become incapacitated. And these parents are frantic because, you know, if you, under an emergency situation, the doctors are going to do whatever they need to do to save you. But most of the time what happens is they get the person stabilized and now there's a decision to be made. Are we going to go to Mary Free Bed to do rehab? Where is this child going to live? And the hospital's looking at the family for a decision maker. And if they don't have a patient advocate form, the parents don't automatically get to make that decision. And so we're going to find ourselves in court so that we can have a decision maker. And for those of us in the room who are old enough to remember Terry Schiavo, do you guys remember her? She was sort of the catalyst for bringing to light the need for a patient advocate designation. She did not have a patient advocate designation. She was 26 years old. She had been a lifelong bulimic, and her bulimia and her anorexia took a toll. She had a cardiac arrest at age 26. Did not have a patient advocate designation, had to go to court to get someone appointed. Her husband had highest priority, so the court did appoint him to be the guardian. But then the reason it became such a big deal is because at some point he said she wouldn't want life support, and her family said yes, she would want life support, and so they were fighting over that. So there was nothing in writing for her patient advocate to say this is what Terry would do if Terry could make those decisions. And so that's the reason that patient advocates are very, very important, so that you have someone in place to do that. Patient advocates are never effective immediately. You can't sign one and say, I want this to be effective immediately. By law, a patient advocate can only be effective when and if you are determined incapacitated, unlike the durable power of attorney, which can be effective immediately. And I should have said this, so I'll go back to the durable powers of attorney. If you have one, or when you get one, you should be taking that to every financial institution that you deal with. And I have that on the little checklist. I said provided to all financial professionals, should be professionals, sorry. Because what I like you to do, or what I like my clients to do, is take that to the bank, take that to their financial advisor, send it to their life insurance company so that those companies can confirm that if someone needed to come in and use that document, that they're good with it. Essentially, they've given it their blessing. They say, yep, you know what, Catherine, if Ken comes to Warner Norcross and Judd and he needs to make a decision about your 401k, we've looked at your document and we'll allow him to do that. I want my kids to be able to go to Chase Bank if I'm not able to make banking decisions, and I want to know that Chase Bank is going to accept them with my durable power of attorney. Why do I want it now? Because if they wait for hopefully many, many years before I'm incapacitated, if they wait until I'm incapacitated and they take that document and Chase Bank looks at it and says, oh, you know, it doesn't have this in it, or we don't like the way this is worded, it needs to be changed. At that point in time, if I'm incapacitated, I can't change it. But if you take it today, when we've just signed it and you have capacity, and Chase Bank tells you that there's a problem, and you call me and you say, you know what, Chase Bank doesn't like number 7, it has to say this, then we can make that change now. So if you have one, make sure that anyone that manages any asset for you has a copy of that, okay? All right, we are going to move to wills. So I'm going to sort of skip to the bottom there and start with wills do not avoid probate. Everyone thinks, boy, if I have a will, I'm going to avoid probate. And that couldn't be further from the truth. It's 100% wrong. Why? The only person who cares about your will is a probate court judge. So I have been an attorney for 30 years, and this is sort of a joke among estate planning attorneys. When you watch a TV show or a movie and they say, we're going to have the reading of the will, and everyone gasps, ah, that drives us crazy because no one has us read a will. I've only ever read a will once. Why? First of all, people don't want to pay me to read a will. I mean, that's just silly. And secondly, if a will is going to be used through the probate court, by law, anyone who's a beneficiary or an interested party in that will is going to get a copy, and presumably they could read it on their own. So what does this even mean, this will? So a will, remember, it's an emergency document. Emergency is Catherine's died. Who's in charge and what are they allowed to do? A will is only in charge of an asset that isn't naturally going to pass to somebody. So what do I mean by that? So if I have a Chase bank account that's jointly owned with my husband and I die, it's naturally going to pass to him because we're joint owners. We own a home together. If I die, it's naturally going to pass to him because we're joint owners. With a house, generally the problem we have is that if I die and now my husband owns it, if he dies of a heartache the next week, there's no joint owner. He might not last a week. No, I'm just kidding. He'd last decades. If there's no joint owner and he dies, who gets the house? And how do we get it to them? So if my kids went to a realtor and said, boy, our mom and dad are gone, they own this house, we want to sell it, the realtor is going to say, well, we need authority from the court. You need to give us authority. Who's in charge to be able to sign a listing agreement? Who's in charge to be able to sign a deed when the house does sell? So when you don't have a joint owner or a beneficiary on an account, so at a Chase account, let's go back to my Chase account. Let's say I had a Chase account and I have no spouse and I die. If I don't have a joint owner, if I don't have beneficiaries listed, then if my kids go to Chase Bank and they take my will and they say, you know what, our mom died, we know she has a Chase account, here's her will, it says right here, paragraph 3, everything equally to the kids. Well, Chase Bank is going to say, well, we don't care, you have to bring us a court order. So sometimes when we're doing estate planning, when we're contemplating, what's going to happen to our stuff when we die, we start backwards and we say, okay, well, who do you want to get your stuff? And how can we most efficiently get that to them? And generally, a will is the very last way that we want your stuff to get to someone. Because if we're using the will, it means that we have an asset that doesn't have a beneficiary, doesn't have a joint owner, and now we're going to have to go to the probate court. And we're going to have to take the will to the probate court and say, okay, here's Catherine's will. It says that she appoints her spouse, but he's dead. So who's next in line? Oh, it's her daughter Chloe. Chloe's going to be the personal representative. When you open up a probate estate, you're minimally going to have to keep that estate open for 4 months. Because by law, when someone dies and you open a probate estate, you have to publish a notice to creditors. So in Kent County, we have to publish in the Grand Rapids Legal News that Catherine's died. And there are companies that literally just have a database where they look through all the legal news throughout the country so that they can cross-reference names. And so, the minute my name gets published that I've died, they're going to cross-reference. And so when I open estates, usually within the first 2 weeks of that publication, if my clients have creditors out there from all over the country, medical bills, whatever it is, I'm getting notices. And so creditors have 4 months from the time that it's published to establish their claim. So that's why you minimally have to have it open for 4 months. When you have an estate, the court is going to be following that. They're going to make sure that everything is handled correctly. And so they're going to be monitoring how your personal representative or your executor is administering the estate. Whereas if you have beneficiary designations or joint owners, you can just do that outside. The family handles it by themselves. With a will, when we die, we have beneficiaries, so we want to know who's going to get our stuff, how they're going to get the stuff, and when they're going to get the stuff. So one example of some really bad planning I'm going to share with you is a client that I have whose nephew's mom passed away, and she had a life insurance policy. And the life insurance agent said, oh, name your son as the beneficiary of this life insurance policy so that it doesn't go through probate. $300,000 death benefit. And she actually, she knew she was dying. She had cancer. So this was like, not even just sort of happenstance, like this was a planned thing. I need to change the beneficiary on my life insurance policy. Well, the problem is that this young man was only 14. And so he was a minor. And when you name a minor as a beneficiary of an asset, you are going to be in the probate court because they're not of age. And you're going to have to get a conservator appointed for this minor. And what happens when you have a conservator for a minor who has money is one of two things. The court is generally going to say that $300,000 has to go in a restricted account. Essentially, they're saying that money isn't going to be touched until that kid turns 18. We're not going to use it for his support or help for the most part. And if you do want to use the money, you have to file a petition with the court to say, hey court, kid has this money and we need it for X, Y, and Z. So it's, it's sort of a pain in the butt if you need to use that money. It does provide some protections, but the next part of that is as soon as that kid turns 18, he's going to get $300,000 plus some interest if it's in an interest-bearing account. Think to yourself of the 18-year-olds that you know or have known who may receive $300,000 and what kind of decisions they might make. Probably not the best decisions. And so one of the things that happens with wills, whether it's through this conservator that I said, or let's just say that I died today, my kids are age 18 to 25. If I died today and everything went through my will to my children and they all got a check, I don't know that all of them would make the best decision. But when things come to you through a will, it's an outright distribution. You have no ability to control how they're going to get that. Another concern, maybe not just be age, but oftentimes I'll have beneficiaries who maybe are on a disability benefit. If you're on a disability benefit and you inherit money outright, it could disrupt your Social Security disability, it could disrupt the Medicaid that you get. So oftentimes I'm getting calls from clients saying, oh gosh, my mom died and I just inherited $60,000 and I'm going to lose my benefits. What do I do? And it would have been helpful if that particular parent had done a special needs trust for that individual so they weren't getting an outright distribution. Other beneficiary concerns are beneficiaries who may have substance abuse issues. Maybe they're in the middle of a divorce, or they're just in this marriage where in the back of your head you're thinking it could go either way. One day these people couldn't be married, but there could be a divorce, and now the inheritance that my child might get might be subject to that divorce. They might have creditors. There might be a lawsuit. So when you distribute out that way, if you know that there are problems, we might want to plan for that. And a will doesn't give us that opportunity. So you're thinking to yourself, Catherine, you haven't said one good thing about a will yet. Why do I even need this darn will? Well, a will is a safety net document. So we do our best when we're meeting with clients to say, okay, who are your beneficiaries? When do you want them to get it? How do you want them to get it? And then we figure out, can we accomplish those goals by beneficiary designations, by joint ownership? Maybe we're going to do a trust. Can we do that so we avoid having to go through probate, so we avoid having to ever pull that will out of our binder? But if we forget, if we maybe had a Chase account when we set this all up and we had beneficiaries, but then we got ticked at Chase and their lousy fees, and we moved to pick any other bank that doesn't have lousy fees, and we forgot to add beneficiaries and we die, now we're going to need that will, because that will is going to tell us what to do with the assets in that bank account. Okay? All right, I'm going to move on. Maybe. There we go. So trusts. A lot of times clients come to me, and they already say to me, we don't need a trust. And then there are clients who say, do we need a trust? Not everybody needs a trust. And I'm going to explain what a trust is. So I often use the analogy that a trust is like a box. And so when you establish a trust, you're building a box that's going to hold assets. And the trust document is the rule book for the box. It tells us who's in charge and who's going to do what with the stuff in the box. And generally when we build our box, when we have our trust, while we're alive, we are the trustees of that trust. So we're in charge. But the trust then also says if I'm incapacitated, much like with a durable power of attorney, here's who are the successor trustees if I can't be in charge of the box. And here's who are the successor trustees when I'm gone, so we know who's going to pull the stuff out of the box and what are we going to do with it. And so if we can't accomplish your estate planning goals by joint ownership or beneficiary designation, that's generally when we're using a trust. So I'm going to give you some examples of when I think a trust is appropriate. So if we have assets that are hard to, I'll come back to that one. With houses. Houses are generally where I might use a trust. Here's why. We can do something called a ladybird deed, and I will talk about that. And that is a way to get your house to your beneficiaries without using a trust, necessarily without it going through probate. So I gave you that example where I own my house with my spouse. If my spouse dies and I'm living, it comes to me because we're joint owners. But what happens when I go? I could transfer my house to a trust, and it's in my box, and my box has the rule book for what's going to happen when I'm gone. So we could put our house in trust. When I use a trust for a house is if clients have more than 2 kids. Why? Oftentimes with the house, I will do a ladybird deed. A ladybird deed, has everyone heard of a ladybird deed? Is that term? Okay. So a ladybird deed is like putting a beneficiary on your home. It would read like this. Catherine Jacobs deeds her house to Catherine Jacobs for her life. And during her life, Catherine is the owner. She can sell it, she can lease it, she can mortgage it, she can paint it purple. But the minute she dies, it transfers to X. So I could say it transfers to my children. I could say it transfers to my trust. If my clients have 2 children, I'll ask them, how do your children get along? They get along great, no problems. In that case, I would probably be okay with doing a ladybird deed that says Catherine to Catherine for life, at her death, to the 2 children. If they say to me, oh, they don't get along at all, that's not going to happen. Why? Because if it says Catherine to Catherine for life and then to her 2 children, at my death, those 2 children own this home. They've got to agree to sell it. They've got to agree on a sales price. And if they can't get along, I'm just setting them up for failure. And so I don't want to do that. And in that case, we're going to have a different plan. If there are more than 2 children, at Warner, if people want to do a ladybird deed with more than 2 children, we make them sign several waivers highlighting why we don't advise that. Because now we've got 3 owners, 4 owners, 5 owners, and they all have to get along. And in Michigan, there is no case law yet that tells us what happens to an interest of a person named in a ladybird deed. So what I mean by that is Catherine to Catherine for life. At Catherine's death, the property transfers to her 4 children. God forbid one of my 4 children doesn't survive me, and I don't change my deed, and so it still says to my 4 children, but when I die, there's only 3 children. The law is not settled about what happens to that deceased child's share. And so that's going to have to be litigated. Does that deceased child's share go to their spouse? Does it go to their children? Would I want it to go to their spouse? Would I want it to go to their children? I don't have a say. Or would the 3 children, instead of getting a quarter each, would they get a third? So there's some issues with that. So I don't like to distribute to more than 1 or 2 children. So in that case, sometimes I'll have clients that have very simple assets. You know, they're in bank accounts, they're in retirement accounts, they're in investment accounts, and we have a house, but we've got a boatload of children. I'll say, you know what, let's do a trust just for the house, because if the house is in trust, when I die, the trustee is going to be in charge. There's one person who's going to say, you know what, I'm the one who's going to list the house. I'm going to decide how much to list it for. I'm going to sign the deed, and no one's going to be able to be challenging that. I'm not going to have 4 kids fighting. I'm not going to have 4 kids and in-laws in their ears. Your brother's always in charge. Why is he like that? We want to avoid that. So that is when I will often use a trust for a house. A trust is also good when we have minor beneficiaries, because we want to make sure that we're not having to go to court to get a conservatorship. We talked about the disabled individuals. And I should just point out, there's different types of disabilities under Social Security. So the type of disability program that people get kicked off of, if you will, if they get an inheritance, are people who are on SSI. So if you're someone who's worked your entire life, you've paid into the system, you usually get something called SSDI. And that is an entitlement benefit. You're entitled to that because you paid for it. That benefit, they don't care. You could have $10 million in the bank and you could still get SSDI because you've paid into it. SSI is for people who have not paid into the system, or they haven't paid very much into the system. And so I think more about some of my clients who've been disabled since birth. You know, they've been born with something that causes them to be disabled. Those individuals are getting an SSI benefit. That is a means-tested benefit. It means that you can't right now have more than $2,000 in your name to get that. So when you get an inheritance, that's when you lose that benefit. That benefit, when you get SSI, it pays you I think 2024, it's $943 a month. So it's not like it's this ton of money. And so maybe you're thinking, well, gosh, if I inherit $100,000, I don't care if I lose that $900 a month. But when you get SSI in Michigan, you also get Medicaid health care. And that's where my clients really don't want to lose their benefit, because they need that health care benefit. Okay? And we talked about a trust allows us to decide how we're going to put up guardrails. So for example, if I use my family, my kids, again, 18 to 25, they're all sort of at different stages in their life. And so my trust allows me to say, you know what, if my children are X age old, distribute half of their share to them. And if they're this old, give them the rest of it. So it allows me to be able to understand who my family is and who my beneficiaries are and how I might want those assets to come to them. I might say, you know what, for these 3 children, if I die, they can have their money. But for this child, let's hold it in trust, because this child can't manage their money, or they're very susceptible to their friends or maybe whomever they're dating, and I'm worried that that money will be, you know, used unwisely. So I can craft how I want that to happen. I almost always put a provision in my trust, and I call it the left-hand turn provision. And so maybe my trust says, if my kids are all 30 when I die, they can all have their money. But my left-hand turn provision says, however, the trustee in their sole and absolute discretion may withhold making direct distributions to a beneficiary if, at the time the distributions are going to be made, they are incarcerated, they are in the middle of substance abuse, they're in the middle of a lawsuit, they're in the middle of a bankruptcy, they're in the middle of a divorce. I even put in there they're in a cult, because I had that happen, and I'm like, well, shoot, I better start including this. Who knows who's going to join a cult? You just don't know. And so it gives that trustee the ability to say, yes, you're 30 years old, but if I distribute this money to you, creditors are going to take it, or the cult's going to take it, or your soon-to-be ex-spouse is going to take it. It doesn't mean that the trustee can't use that money. Hey, beneficiary, we'll pay your rent, we'll pay your mortgage, we'll make sure you have groceries, we're going to get you a nice reliable car, but I'm not going to write you a check for cash, because if I do that, that could be a problem. So a trust allows us to put up some parameters, some guardrails to make sure that the way that our beneficiaries get their assets is going to be the most beneficial to them. Okay. Trust funding is very important. I have a lot of clients who come to me and they have a trust, and we'll talk about the trust, and I'll say, okay, well, what's in the trust? And it's just sort of this blank look, like, I don't know, what's in the trust? And so that's an important piece. That's sort of the devil's in the details. So remember, when you create your trust, you built a box. And so we really want to make a list of all of your assets. You know what? I have these bank accounts, these credit union accounts, retirement accounts, annuities, life insurance with cash surrender values, really understanding all of your assets and then identifying, should this asset have just beneficiaries on it? Should this asset be in the trust? Should there be joint owners? And making sure that when you go to bed at night, you can say to yourself, we know with 100% certainty, if we didn't wake up in the morning, we know each asset is going to flow to our beneficiary via whatever method, beneficiary, joint owner, or trust. And so if you can't go to bed tonight and really know that with certainty, then really that's something that you should be thinking about, because that probably means that we're going to have to be in probate. If you can't answer that question, it probably means you're going to be in probate. One of the other things is deeds for property, and I do want to spend a little bit of time on that because people a lot of times love to do their own deeds, and people like, I shouldn't say it this way, I'm going to say a big request that I get, especially from little old ladies, is, will you prepare a deed for me and put my kids on the deed? Anyone ever heard of that? Let's add our kids to the deed. Why would anyone want to do that? Void probate. And that's 100% true. If today I added all 4 of my children to my deed, and I'm the only person, get rid of my husband, knock him off, it's just me, and I think, oh, actually, I'm going to give you a very good example. First case out of law school was my mother-in-law, and I had permission to share this story because she's also dead now, but she lost her husband when he was 59 years old. She worked at Comerica Bank in the mortgage department. Her very helpful friend said, hey, Terry, you better add those kids to the deed, because if you die now, that house is going to go through probate. So within 10 days of my father-in-law dying, she added my husband, his brother, and stepsister to her deed. Puts the deed away, no issues. 10 years later, she decides, I'm going to retire, I'm going to sell this house, and I'm going to purchase a condo. The realtor comes over, talking, she tells her about the deed, and the realtor says, oh, well, Terry, you need to have all 3 of the kids sign the listing agreement because they're all owners. Oh, okay, no problem. Calls the boys, sure, Mom, we'll sign the deed. Had sort of lost her relationship with her stepdaughter after her husband died, and the stepdaughter said, oh yeah, I'll sign the deed, but I want a check for 25% of the house. And she was 100% entitled to 25% of the house because she was an owner. Now, fortunately, at that time, there was a case that allowed us a little bit of a workaround, but since then, that case has been overturned, and today we wouldn't have had a good result. But the minute you add children to your deed, they are owners. The minute you add anyone to your deed, they are an owner. And there's no take backsies. You can't just say, okay, I'm going to undeed it to you, and now I'm going to draft a deed that says, I take that all back. You can't do that. The only way you can get them off your deed is if they sign a deed saying they are transferring the interest back to you. So that's number 1. Number 2, when you add a child to your deed, not only are you adding that child, and when I say child, I just mean anyone, but more common than that, it's we're adding a child. So when you add that child to your deed, you're adding them and all of their sins. And what I mean by that is, if your child owns this property with you now, and they are driving and they hit someone and get sued, your home is an available asset to that lawsuit. If they are being sued by a creditor, your home is an available asset because they own it. If they get divorced, property settlement asset. If they file bankruptcy. So you expose your home when you add them to the deed. Another reason, when you add someone to a deed, you kind of screw them over for taxes. Why? Well, if I bought my home and I paid $100,000 for it, and in 2024 I add all my kids to the deed, put them on it, now they're owners, gonna avoid probate, yay me, and I die 10 years from now, and when I die, my house is worth $500,000. I have $400,000 in gain. Because I added them to the deed, they are all going to have to recognize that $400,000, and each one of them is going to be responsible for $100,000 of capital gains tax. If they receive my house via my death, through a ladybird deed, or through my trust, they get what's called a step-up in basis. So when they inherit it, they get it at $500,000 instead of $100,000. So when you add someone to your deed, you are causing them a huge tax problem. Fourth reason, when you put someone on your deed, you're giving them a gift. And so we all hear, oh, you can give a gift of $10,000, $15,000. It's actually $18,000 in 2024 without paying taxes. And that's not exactly correct. What you can do is you can give a gift of $18,000 to anyone in 2024, and you don't have to file a gift tax return. It means you don't have to report it to the IRS. If I add my children to my deed, and if it's worth $500,000 today, and I'm giving them all a 20% interest, I've given them all $100,000. So technically, in that regard, I should be filing a gift tax return to report to the IRS that I've given this gift. It doesn't mean that I'm going to be paying taxes on it, but it does mean I am required to file that gift tax return. So when you add someone to a deed, you are supposed to file a gift tax return. Last reason, and there are many other reasons, but these are my 5 biggies, if you will. And this is just from my perspective, as part of my practice is elder law, and so I'm helping people when they need to apply for Medicaid to get in-home help. If you add someone to your deed, Medicaid looks at that as a divestment. So I'll give you an example. I had a client who bought a condo. She had sold her home, paid cash for a condo. I'm just going to call it $150,000 she paid for it. And at closing, because she paid cash, she said to the title company, will you put my children on the deed because I want to avoid probate? And the title company did that. So at the closing, she got her house, and all 3 of them were on the deed. About 4.5 years later, she had a stroke. It was a very severe stroke, so then she was in a nursing home, and she wasn't going to get out of the nursing home. So her family said, oh, we're going to apply for Medicaid because this nursing home is $12,000 a month, and we don't have the money to pay. In Medicaid, if you give away an asset within 5 years of the date that you're applying for Medicaid, it's a divestment. And a divestment means that you've given away money and they're going to penalize you. So let's just say that it was today that this was all happening. And so in March of 2024, this client wanted to apply for Medicaid. They would say, from March of 2019 forward, have you given away any gifts? Have you given away any money? That client would have to answer yes, because 4.5 years ago, she added all those kids to the deed. And if, in this case, if she gave away 2/3 of that home, it's $100,000. So Medicaid may say, well, you qualify for Medicaid, but because you gave away $100,000, we're going to penalize you. And in Michigan right now, for every $10,870 you give away, it's a 1-month penalty. So if we just round that down for easier numbers, essentially for 10 months, they're not going to pay for her nursing home care. So she'll pay that $12,000 a month, and after 10 months, then Medicaid will kick in. So clients come to me like that all the time, and I try and think, okay, how can we fix that? Well, in this particular case, it was like a perfect storm of really bad dominoes. So we have this divestment. So I say, oh, well, we can fix that divestment. The 2 of you kids can deed your interest back to mom. So mom could say, yep, Medicaid, I gave away $100,000, but we cured it because the kids gave it back. No problem. And that would work, and we could apply for Medicaid. But in Michigan, there's something called estate recovery. And so in the state of Michigan, if you receive a long-term care Medicaid benefit, so a nursing home benefit or a Medicaid waiver in your home benefit, those two Medicaid programs, there's something called estate recovery, which means if you have an asset that goes through the probate court when you die, the state of Michigan can put a lien or become a creditor of your estate for however much money they paid for Medicaid. So going back to my client, so in Michigan, in my client's case, she gave away $100,000, right? Kids deed the house back to her, and we're all good to go. But now the house is just in her name. If she dies, where's that house going to go? Through probate. And the state of Michigan can then put a lien on her home. So then I think, okay, well, what's the next solution that we could do? Well, if we had a durable power of attorney that had powers that gave the agent the power to transfer property, that agent could have prepared a deed. So we deed everything back to mom. That agent under the power of attorney could say, or could prepare a deed saying that mom transfers it to mom for her life, but at her death, then it transfers to the kids. The agent under the power of attorney could create a ladybird deed. Guess what they didn't have? Durable power of attorney. So they could not do a ladybird deed. So it was just like one bad thing after another. And so I bring that up just to say that with deeds, we have to be very careful, and we have to understand how do we want that deed. The house generally is one of our biggest assets, maybe our retirement account, but a house for most of my clients is one of their biggest assets. And so we're working through that, and we're saying, what is the best way to get it to the people that we want, how we want, in the most efficient way that's not going to cause problems. And so I would tell you that there's probably, I can't even think off the top of my head of one scenario where someone came to me and said, will you please add my children to my deed, where I would say, yeah, that's a good idea. Because even if I put a deed together today and the person died the next day, I've created that capital gains tax issue, for one. So we just generally don't do that. Questions? It was a lot. It's like drinking from a fire hose. Yeah.
So we just recently added my name to his deed, or what is this, okay?
No,
Okay.
because you're married. Not married? Oh. Yes.
We live in Sin.
You go, girl. So technically, yes. So now I have to do this on camera. The IRS says that if you give a gift of more than $18,000, you are supposed to file a gift tax return. Why do you have to file a gift tax return? So we're going to go in the weeds on gift tax here for a minute. Today, you can all rest easy knowing that you could die today and the first $13 million of your estate is going to pass tax-free. But every dollar you have over $13 million is going to be taxed, okay? So what that means in your example is that when we die, the year that we die, they say, okay, what's the estate tax this year? So if we die in 2014, $13 million we get to protect. The gift tax returns that we filed when we give away these gifts are placeholders. And so if I died in 2024 and I had $12 million, which would be very nice, if I had $12 million, they're going to look back and they're going to say, over Catherine's lifetime, has she filed any gift tax returns? And if so, they're going to add those all back up and add them to my $12 million. So if they added them back up and I had $2 million worth of gifts that I've given away, they're going to say, okay, well, now you're at $14 million. You've got to pay taxes on that $1 million. So most of my clients that I'm working with don't have gift tax return issues, or I'm sorry, federal estate tax issues. Really, you're filing that gift return so that you can say, if I die, here's what I might have to pay taxes on. So if you don't think that you're going to have a federal estate tax issue, you're probably going to be okay. Right. I can't tell you that you shouldn't file a gift tax return, but I'm just going to say you're probably not going to have an issue. Now, I should also mention that the current federal estate tax laws, this 13 million, expires at the end of 2025. In 2025, it's going to go back down to about 5 million. It's going to be adjusted for inflation, probably 7 or 8 million. There are people who were very concerned, so this is just sort of the politics of federal estate tax. So when Obama left office, the federal estate tax was at 5.5 million. And when Trump was elected, everyone said, oh, Trump's going to do away with all federal estate tax. Well, he didn't do that, but he did raise it to 11 million. And it's been adjusted for inflation ever since. So now there was a big concern when Biden was first elected that he was going to change that law and drop it back down. That never has happened. There's been bigger fish to fry, apparently. So that hasn't changed. But in 2025, it will drop back down. And people say, well, it may drop back down, depending on who's elected, back down to 1 million. This is my call, so I'm going to put money on this one for all of you. I don't think it'll ever drop down below 5 million. Why? If we look at who's in charge of making that law, even though they only make 174,000, and I say only, they make 174,000 a year, but they all have millions. And the people who get them elected all have millions. And so it's either going to stay very, very high or it's going to go away. So to answer your question, should you file a gift tax return? You're required. Should you? That's up to you, but probably not a big deal. Yes. It's a long answer, sorry. Sometimes I'm verbose.
But if he passes and it goes to her, she's going to have capital gains when she goes to sell
Yes.
the house too, right?
Yep. Thank you, Katie.
So it's not a
Katie's
good
my
idea-
wing woman. Say that again?
It's not a good idea to have her be on the deed?
Or maybe a better option
Yeah,
would be
a
that it
Trust or ladybird deed.
We had a lady,
Ladybird deed.
we had a ladybird deed and then we switched it because we heard things about the, not, we heard some things.
I mean, the best thing would be just creating a very simple trust. You could have a trust that says, at my death, my house, if I still own it, transfers to my beloved, my sinner. No, I'm just kidding. Your words, not mine.
Right now, having her on the deed, that could be a liability issue too. That was always my concern,
You mean like an insurance liability issue?
any type of liability. If somebody
Right.
comes
Oh,
after the
sure.
company,
Sure, because I will tell you this, so you bring up an interesting fact or an interesting point of law. In Michigan, if you own your home as a married couple, you automatically get something called tenants by the entireties, which is a creditor protection. So if I'm driving home today and I run someone over and they sue me and I don't have enough insurance coverage and they're going to try and go after me for the excess, my home is protected because my husband and I are married. Now, if I was single, I wouldn't have that protection. So in your case, because you're not married, if you were driving today and you injured someone, they could sue and the house is exposed.
I hear wedding bells.
Surprise! We're all here. So it might make sense that, a ladybird deed I feel like is a good option, but you could always do a trust, and that trust could have provisions in it that provided for how you wanted the house distributed when you're gone. But there's certainly that capital gains issue too. So.
Does the trust protect you if you said you were in an accident and you're single?
So no, it depends on the kind of trust that you have.
The house, that is.
Yeah, right. Most trusts that people have are called revocable living trusts. Trusts that we could revoke, that we could amend. They're really meant to avoid probate. They do not provide any creditor protection for the person who set them up. There are certain kinds of trusts that are meant for creditor protection. Sometimes we do trusts to avoid assets being counted for Medicaid. But those particular trusts are generally irrevocable trusts, and you give up the right to amend them, to revoke them. When you put assets in them, you no longer have control over those assets. So a revocable trust really is meant for probate avoidance, to be able to control how things are going to go because you need to put up guardrails or whatever it is, and for privacy. Trusts provide us with privacy. I should have mentioned that the probate process is a very public process. So if I died today and my family opened up a probate estate, not only do they have to go to court and file all these public documents, but in those documents, using me as an example, it's going to list that my heirs under my will, if I had a will, for example, are my 4 children. And those public documents are going to list my 4 children's addresses. So now everyone could know where my children live. And 90 days after my probate estate is open, my personal representative has to file an inventory. So they have to file a public document that says what assets of mine are passing through probate. And so let's say I'm a 90-year-old woman and I have 4 children listed. So we know those children are going to be in maybe their 60s or their 70s, right? Well, who is a prime target for scams? Our older adult population. And so now scammers know that this 90-something-year-old woman, because my date of birth is on these documents, my date of death is on these documents, my 4 children's names are on the documents, and let's say that I had a life insurance policy and a house, and let's say it was all worth $2 million. Well, now people know that my 4 kids are each going to inherit about $500,000. And that's all public knowledge. And they can find out where they live and a lot about them. And I will tell you the scams that are out there. I had a client come in last week and dad had been scammed out of $40,000. And it was the most, it was just mind-blowing. So this, on the internet, their dad somehow was told, hey, you can open up this appliance selling company and our people make all this money. And you just sign up here and we will get you incorporated. And they actually got him incorporated at the state of Michigan. They got him an LLC. And we will prepare a website for you. And they did. They prepared a website for him. And you just have to keep paying and keep paying, keep paying. And now you got to send us the money so that we can secure your inventory. And don't worry, we'll hold on to it for you. You don't have to get a warehouse, but you do have to pay rent for the warehouse. Oh, and it's so difficult for you to pay. Why don't you just give us the routing number for your bank account, and when the money becomes due, we'll just take it out. And they would literally only take out what they told him, build that trust, build that trust. And then, they never bought any appliances. Like he didn't have $10,000 of appliances that he paid for. But then they transferred money from his savings to his checking. And they told him, oh, we put money in your checking accidentally, can you send that to us? And he wasn't thinking, and he sent them the money that they took out of his savings from his checking. They sent that back to them. And they just kept taking it. And then finally, when he started getting a little bit like, this doesn't seem right, they wiped out the account. So sophisticated. And so it's just, we have to be just very careful. Very careful.
We have a Facebook question talking about what's the average cost of setting up a trust, or how does that work when it comes to deciding to set up a trust?
Sure. So I would say, I can only speak for myself, and I would say that just knowing lots of colleagues who do the same thing that I do, it's all over the board. So I will tell you what my range is, but I'm going to tell you this. Well, I'll just tell you my range. So if I'm doing a basic estate plan that's wills and powers of attorney and a deed, it's probably going to range anywhere from about $800 to $1,500. If we're adding a trust in, it's probably going to be anywhere from $2,000 to $3,000, and that just depends on how complex the trust is. So anywhere from $800 to $3,000 is generally about what Warner is charging. Yeah.
What about taking names off deeds?
Depending on the deed, I would say probably in the mid hundreds to do that, to get the deeds recorded. So I would say you should never have to take out a mortgage to pay your attorney for estate planning, and there are some attorneys who charge enough where some people are taking out mortgages You should never have to do that. You should never be paying more than, I mean, this is just my opinion, but if you go to an attorney to do estate planning and you don't have a taxable estate, you're what I would call everyday people, house, maybe life insurance and retirement accounts. If you're paying more than $4,000 or $5,000, I would say get a second opinion. I would say that there's a concept that big firms are more than small firms. I don't find that to be true. So.
How often should you update or review it?
Well, that is a really good question, which is why I gave you that little form. So that's a good review for you every year because you're looking at it and you're saying, oh, we named our sister Mary to be our executor. And now our kids are, adults and they could do that. So I'm looking at that. I should probably change my documents. So if you have a major life event, you should be looking at your documents. A spouse dies, a spouse becomes incapacitated, you get divorced, you have a child die, your children become adults. Every couple years, you should definitely at least be looking at it. For my clients, they will call me. I say call me whenever you want, but call me every couple years. Let's just revisit it and say, you know what, is now a good time to change it? Oftentimes, everything's still good to go, and we don't need to change anything.
And the final question from this way is, so 18-year-old, when your child turns 18, should one of the birthday presents be power of attorney paperwork? And
Yes. All of my kids at 18 got patient advocate forms, and my oldest daughter was so indignant. She said, all I really wanted was boots. And our second oldest daughter, who's sort of my envelope pusher, said she signed her documents and we put them in an envelope, and she pulled out a Sharpie and she wrote on it, Mallory's death papers. And I said to her, well, joke's on you, because those aren't good when you're dead, so there you go. But all of my kids got those because if something were to happen to them, I want to make sure that it's seamless for my husband and I to step in. And I tell them, you know what, you don't want to name us, name one of your siblings. They're all adults, but have one. Every 18-year-old should have one.
What is your opinion on naming, like, someone that is not related to the family in any way, or like as a, for the patient advocate stuff specifically?
I think it's case by case. I mean, there are some family members that probably never should be named to do anything for anybody. And sometimes it's better to have
Or
someone not
like,
family.
is that something that it's like, say you don't want to put your family through, like, making those decisions?
Right.
Or have to be the one to make the decision to pull
The
a
plug. Yeah. And there are, sometimes I have spouses who will say, I don't want to be in that role. If those decisions need to be made, I just want to be there for my loved one and let someone else make those decisions. I find in blended marriages, blended families, I should say, that is someplace where I think you really need to have a patient advocate, because what happens sometimes is, you've got the stepmom, dad's, on his deathbed, and we've got to make decisions, and the stepmom is saying, I should be making those decisions, and the adult kids are saying, no, I should make those decisions. In that particular case, we should have a decision maker in place, and in my opinion, those kids and that stepmom should know about that in advance. The last place you want them to find out is when they're standing across the bed over you. And that goes with estate planning as well. People always ask, should we share our estate plan with our kids? And I would say yes. And it's the extent to which you share depends on the family, but certainly you want to tell the people who are in charge. And so if, I've used my example of poor Chloe. So if Chloe is going to be the executor or the trustee of our trust, I would want our kids to know that, because I can guarantee in my family, my second oldest deaf daughter, she's going to be like, wait a second, why am I not in charge? And I don't want there to be a fight when I'm gone. So I'm going to tell them that. I think it's always good to tell the kids, look, you know what, we're splitting everything equally, or we're splitting things unequally, and here's why. Because even if you split it equally, if we said, you know what, we're splitting it equally, you might have the kids who say, well, wait a second, why is Chloe getting the same amount? She went to a really expensive school. You paid for her wedding. This is all not true, but she wishes. And she got all this money, and I just went to community college, and then I got a scholarship, and I eloped, and you've paid all this money. You should take that into account. And so while I'm alive, I would rather know about that so I can talk to them and say, well, here's why we're going to do that, or I hear what you're saying, because when I'm gone, I don't want those other kids to carry that with them for the rest of their lives. I want them to feel good about it. Or maybe I did do that. Maybe I said, well, Chloe's only going to get this percentage because we did give her all that money. And I want her to know why we did that. So if she's looking at the will and she's like, wait, why is everyone else getting, 30% and I'm not getting the same amount? I'm only getting 10%. I want her to know why. So when we're doing estate planning, we're trying to avoid family fracturing. And so everything we can do to avoid that, we want to do. And sometimes it's sharing that, because once you're gone, you can't give that explanation. And Chloe may always be wondering, why did Mom hate me so much? I'll give you reasons. No, I'm just kidding. Kidding, Chloe.
Gentleman had a question.
Yeah.
I interrupted him a couple times first. The gentleman in the blue.
Oh, what's the difference between a conservator, a trustee, and an executor?
An executor is the equivalent to a personal representative, and that's the person who's in charge of your will. So an executor is not a term we use in Michigan. We use the word personal representative, but that would be someone who's in charge of the will. A trustee is the person who's in charge of your trust, and a conservator is a court-appointed person to manage your finances while you're incapacitated. So if you don't have a durable power of attorney and someone needs to manage your finances, the court is going to appoint a conservator. And I should tell you why, another reason why it's bad to have a conservator if you can avoid it. When you petition the court to become someone's conservator, so let's say that my husband and I didn't have durable powers of attorney, and now he's incapacitated and I have to become his conservator. I'll give you a better example. Let's say I'm dead and Chloe's got to become his conservator. Chloe is going to have to go to court. We're going to have to say her dad's incapacitated, but then the court is going to say, okay, Chloe, you have 56 days to file an inventory. You have to tell us all the assets that your dad has that you're in charge of. So she files this inventory and it says that, Ken has a house and a retirement, whatever it is, okay? He's got, let's just say, $500,000 worth of assets. At the end of the year, Chloe is now going to have to file an accounting. We call it a fiduciary accounting of conservator. And she's going to have to tell the court, here's all the money that came in, his Social Security, maybe gains on his investments, and here's all the money that went out. We have to file that accounting with the court. It has to go to all the interested parties, so in Chloe's case, all of her siblings, and then the court is going to have a hearing to approve that. And so there's this, the court is in your business, and you're going to have to report for all of that. And if a home is owned by Ken, in this case my spouse, Chloe can't sell that home. Let's say he needs to go into an assisted living. He's not living at home anymore. She can't sell that house unless she gets court permission. And in Kent County, you can't sell the house until you get an appraisal, $2,000. And you have to have an offer on the house before you can even petition the court. And so you get this offer on the house, and you've got to tell the buyer, look, we're not going to close at least for another 30 days because we have to get court approval. So it is a lot of rigmarole. It's a very legal term, rigmarole. So it's very important to have that durable power of attorney. I can't stress that enough. Yeah.
What do you guide people with that do not have anybody family-wise that they would want to be their set people of durable power of attorney, patient advocate? Where do you head them towards?
Yeah, that is a tough one, and more common than you would think, quite honestly. There are a lot of people who come in and they don't have family. Certainly we try and look towards friends, trusted friends if they have them. But then it oftentimes is that the friends that you might have are the same age as you, and so as you're getting older and maybe need help, those friends are kind of falling off. Digging deep into family, nieces, nephews, if that's possible. But if not, there are some private companies who do that. There are companies that specifically will act in that role. You do have to pay them.
What are those companies called?
Off the top of my head, I could email you several of them. I can't think of them off the top of my head. There's, it used to be Warfield Waterway and Willett something, and they incorporated, so I can't think of their name. They're one of them. Sometimes banks will do that, but there are some professional corporations that will act in that capacity.
So maybe my lawyer would even have,
Mm-hmm.
okay.
Yep, and maybe your lawyer would even act in that role. Sometimes lawyers will act in that role. Some CPAs will also act in that role. I know that there's a group at Raymond, REHMANN, they're a CPA firm. There are a couple of their CPAs who act in that role. Just as sort of a shout out to the Area Agency on Aging of West Michigan, they have something called a daily money manager program, and so it's a program that it's a sliding scale of fees based on your income, but that daily money manager program is for people who are having trouble managing their own bills, and they will help you pay the bills, and it's all done online, so it's very transparent. So maybe you've got adult kids who live far away and can't really help you with that. It's all online so people can watch what's going on, and so that's part of the funding from the senior millage in Kent County. So Kent County, I have to say, is a great place to age because we get a lot of money from the senior millage that we all vote on, and the Older Americans Act. So through the Area Agency on Aging, they're a great first place to go for resources.